We're excited to offer probate services in Midwest City, Oklahoma. Regular probate proceedings. The attorneys will first determine if there is a last will and testament, a pour-over will, or there's no last will at all. If your loved one died without a last will, this is called dying intestate. The lawyer will draft an initial petition for probate, just like in the summary we talked about in the last video. If the client agrees with the writing, then the law firm will have them sign the petition and will file that petition for probate with the court clerk. The judge will order that the petition be heard at some future date, usually 30 days into the future. Probate lawyers will also publish notice of the hearing in the local newspaper and will mail a copy of the notice of hearing to all interested parties, the heirs and beneficiaries. This is usually done by certified mail so that we can prove that they got it and that we actually tried to mail it to them. At the initial hearing, the court will usually make 4 determinations at that first hearing. Number 1, does the court have jurisdiction to hear this matter? If your loved one did not live in or have assets in that county, then that county district court may not have jurisdiction. If your loved one had a house and lived in that county, then that county court probably has jurisdiction. Number 2, is there a valid last will and testament, and should it be admitted into the probate process? Number 3, who should be the personal representative of the estate? The executor or personal representative is usually a family member and is the person who usually hires the probate attorneys to file the probate. Number 4, who are the legal heirs to the estate? These are sometimes the beneficiaries. The judge will issue an order stating exactly who those legal heirs are. This is important because these legal heirs now have the legal authority to consent to the sale of real estate being sold during the probate. It's also helpful to know whether the estate is going to be split 4 ways or 3 ways, right? Once the court has made those 4 determinations, it will usually appoint the petitioner as the personal representative. A personal representative is sometimes called the executor, just depending on where you live. This personal representative is charged with administering the estate of your loved one. This involves gathering and identifying all the assets, settling claims, administering the estate, and finally distributing what is left over to all of the heirs. Depending on your state, creditors usually have 60 days from the filing of the notice to creditors to file a claim against the estate. The notice to creditors is published in a local newspaper in the county where the probate is being administered. Notice to creditors is also mailed to all known creditors of your loved one, again by certified mail. If a creditor files a claim against the estate, then the personal representative decides if it is valid and whether or not it should get paid. That claim then must be approved by the court before any payment can actually be made. Next is a general inventory that lists all of the estate's assets. This list usually includes what is in the estate, such as personal property, mineral interests, real estate, and any financial accounts. When real estate or personal property needs to be sold to satisfy debts or to just have money available for distribution, the personal representative will make an application. Earlier, I stated that the court determines the legal heirs of the estate at the initial hearing. Because the judge has made that determination, all of the beneficiaries have the legal authority to consent to the sale of real estate or personal items by the personal representative. They have to give the personal representative their permission. If they do, then the executor usually sells the house with a realtor and deposits the proceeds of the money into the estate bank account. This is a separate estate account, not the bank account that your loved one had during their lifetime. Once the personal representative has gathered all the assets, paid and settled all the claims, then and only then is the estate ready for closing. This is usually done by a final account, and you guessed it, another pleading with the court. Notice of that hearing for final account is published in the newspaper, mailed to all interested parties by certified mail, and usually set for some future date, usually 30 days into the future. As you can see, if everything goes perfect, a probate will take 4 to 5 months. They never go perfect, and they usually last 5 to 7 months here in Oklahoma. If the family starts fighting, then that may even add years to the process. We've had that happen on a regular basis where the family just can't get along, and it takes years because it's hard to get onto the judge's schedule to have hearings for their fights. So the best thing that you can do is to get along with your family. I know I've thrown a lot at you today, so that's why we've prepared our free guide on estate planning. I'll put a link to it in the description below and in the comment section below that so that you can download it and get started in the right direction. And to help you out even more, watch this video up here and this video up here. If you enjoyed this video, then guys, please smash that subscribe button and click on the like button. And also click on that little bell so you'll get notified every time we post a new video. Have a great day and an awesome week. And as always, thanks for watching.